So, in effect, this is not a warrant, it's a permission slip. It's a green light from another ICE agent to go bash down a door, smash into a home, detain and arrest someone without a judge finding probable cause and without any sort of objective, independent.
Senator Richard Blumenthal of Connecticut did not open this exchange by shouting. He opened it with the Fourth Amendment. Then he showed the record. ICE agents at the Minneapolis home of Garrison Gibson. A door forced open. A man detained in front of his wife, his 10-year-old daughter, and his niece. Then came the document. An administrative warrant, not signed by a judge, not issued by an independent court. According to Blumenthal, signed inside the ICE system itself. And then came the memo. A May policy bearing the witness's signature, which Blumenthal says the public only learned about because 2 whistleblowers came forward. A home, a family, a memo, a constitutional line. Watch how Blumenthal builds the record.
So, in effect, this is not a warrant, it's a permission slip. It's a green light from another ICE agent to go bash down a door, smash into a home, detain and arrest someone without a judge finding probable cause and without any sort of objective, independent finding. Is that correct?
No, sir. So the I-205 is the arrest warrant, but the I-205 is based on an executable final order issued by an immigration judge from the Department of Justice.
And that order is from an immigration judge who is part of the executive branch, not an independent judge. But the warrant issued is simply a permission slip. Now, let's be very clear. You were a local police officer.
Yes, sir.
To bang down a door, barge into someone's home, if you're the FBI or a local police officer, you need a judicial warrant from a judicial officer, a judge, who is going to find or not probable cause, which has a specific meaning under the law. These ICE agents are banging down doors, doing the same thing without that kind of judicial warrant. What is so different about ICE that it regards itself as an exception to the Fourth Amendment? And the requirement for a judicial warrant is a Fourth Amendment requirement.
We don't, Senator. There is case law, U.S. versus Lucas, 2007, which is out of the 8th District of Minnesota, which authorizes the entry of a home to catch a fugitive based on an administrative warrant.
I beg your pardon, sir. It does not abrogate the Fourth Amendment. It does not say that ICE agents or CPP agents can simply bash down doors and barge into people's homes, terrorize their children, detain and arrest people without a judicial warrant. And there is nothing different about what ICE does as compared to the FBI or local police that would justify it. The policy that they're acting under, in fact, is the result of a memo that you issued in May. You're familiar with it.
Yes, sir.
Has your signature.
Yes, sir.
Which says, in effect, they don't need judicial warrants. They can act on the basis of the 205 warrant that you've just described, which is administrative. It's not judicial.
So let's talk more about it.
Why did you keep this memo secret?
I didn't keep that memo secret, sir. It was blasted out.
We learned about it when 2 whistleblowers came to us and said that you were using it as a basis for the policy. It was never announced publicly. It was never released to the press or the American people. Why did you keep it secret?
Sir, I didn't keep it secret. If sending an email to a workforce of 30,000 people is keeping something secret, it's a bad secret.
It never reached those people.
Yes, sir, it did.
Well,
The email did, sir. Yes, sir. I can work with your committee to get your staff to get that.
Let me move to another topic. You stated on Tuesday, quote, no U.S. citizen is subject to immigration enforcement and that doesn't happen. If a U.S. citizen is detained in the course of the immigration investigation, they are quickly released. I ask unanimous consent that a report that we did, the ranking member staff did, entitled Unchecked Authority. It documents 22 U.S. citizens being detained and assaulted by immigration agents, as well as written statements from 8 U.S. citizens who have been detained, shot at, and nearly killed by ICE agents who came to speak.
Without objection.
Thank you. So let's take George Reitz, for example. He's an Army veteran, a father from California, trying to go to work. He said he was tear gassed and held for 3 days without charges. Is he lying?
Sir, ICE wasn't involved in that arrest, sir.
Were you mistaken when you said that no U.S. citizen is subject to immigration enforcement?
No, sir.
Well, who's lying, you or him?
Sir, I'm speaking for the men and women of ICE in my operation. I didn't arrest that individual, sir.
But the facts contradict what you said. Will you admit that you don't know, for example, about Alaya Rahman, a disabled woman from Minneapolis? She came to this hearing. She testified before our Spotlight forum, violently dragged from her car, detained without medical attention until she passed out. She lying, or are you lying?
No, sir, she's not lying.
Well, then you were mistaken when you said no U.S. citizen has been detained.
No, sir, I said no U.S. citizens subject to immigration law and deportation or removal. ICE does
Well, that's
detain.
a circular argument. She wasn't subject to immigration law because she's a U.S. citizen, but she was detained, and that contradicts directly, as does your statement applied to Miramar Martinez, who was almost killed, shot 7 times by CPP agents. It is true of Diana Figueroa, who told us she was violently dragged from her car after dropping her son at school, thrown into a van, also detained. Is she lying?
No, sir. But, sir, you know, I've worked personally with you on many cases when you come to me on constituents, especially in Connecticut when I was a field office director in New England. You know that I am transparent and we do not lie. So to say that we're lying is incorrect,
I asked you
sir.
first whether you were mistaken when you said that no U.S. citizen, I'm quoting, is subject to immigration enforcement.
Correct, sir.
Enforcement.
Enforcement
I
is
would
an
call
arrest,
that-
removal.
I would call that misconduct enforcement by your agents. I'm out of time. Thank you, Mr.
Let's go and stop there.
What makes this exchange dangerous is not only the force described at the door, it is the paper trail behind it. Blumenthal does not ask the witness to react to a rumor. He builds the record from documents and named examples: the Minneapolis home of Garrison Gibson, the administrative warrant, the signature, the May memo, the whistleblowers, and citizens who, according to the report, were detained or assaulted during enforcement. The witness gives 2 defenses. The first is legal. He says the I-205 is an arrest warrant based on a final order from an immigration judge. But Blumenthal is asking a narrower question: who gave permission to enter a private home? Whether an independent judicial officer reviewed the facts before agents crossed that threshold. That is why the word warrant matters. Most people hear warrant and think court order, a judge, probable cause, a neutral check before the government moves from public authority into private space. But the document Blumenthal describes is administrative. According to him, it was signed inside the ICE system itself. If that is enough, the agency is not just enforcing the order, it is helping authorize intrusion. The second defense is secrecy. The witness says the memo was not kept secret because it was emailed to 30,000 employees. But internal circulation is not public disclosure. A memo inside an agency is not the same as a policy announced to Congress, explained to the press, and shown to the American people. Then Blumenthal widens the frame. He brings in unchecked authority. He says the report documents 22 U.S. citizens detained and assaulted by immigration agents, plus written statements from 8 citizens who say they were detained, shot at, or nearly killed. The witness narrows the language. He says no U.S. citizen is subject to immigration law, deportation, or removal. But that is not the same same as saying no citizen was detained. That distinction may protect the agency's phrasing. It does not resolve the facts placed on the permanent record. This is the pattern the hearing exposes: executive power using technical definitions to survive public scrutiny. An administrative warrant becomes a warrant. An internal memo becomes not secret. A citizen detained during immigration enforcement becomes not subject to immigration enforcement. The problem is not just one door in Minneapolis. It is the precedent. If the government can redefine the warrant, disclosure, and detention, accountability becomes a matter of vocabulary, and constitutional rights should not depend on the agency writing the memo.